Good afternoon, everyone, and welcome to our Tech Talk today on leveraging playbooks for your regulatory data classification needs. We'll give uh, everyone a few more minutes to join, and then we'll start talking on the presentation. Thank you. All right, everyone. Thank you again for joining our Tech Talk on leveraging playbooks for your regulatory and classification needs. I'm Robert Server, and I'm joined today by my partner here, Scott Giordano. Let's go ahead and advance to a couple of housekeeping items first. If you're having trouble viewing the screen, check your computer's audio and visual settings. Send us a chat. If we get multiple chats, we'll know it's on our end. I tried to make this slide deck fit the screen appropriately. You may need to zoom in to see more detail. And we have questions. We have time for questions at the end. Feel free to use the chat to send us a question. We'll try and answer it in line if we can. If we don't get to your question during the session, we'll get it in a follow-up. Also, this webinar is being recorded. An on-demand replay will be posted in the Spirion customer portal and available on your BrightTalk channel. All right. So today, I'm joined with my coworker, Scott Giordano. Scott, would you like to introduce yourself?
Yes, Scott Giordano. I am our General Counsel and Chief Privacy Officer. I've been here for a little over 3 years, and thank you for inviting me to your presentation.
All righty. Thank you so much. And as usual, I'm Rob Server. I'm Field CTO at Spirion. I've been with the company for 8 years, coming up through sales engineering and holding a number of roles here at Spirion. So let's go through today's agenda, and we're going to answer a couple of questions here, starting with what does regulatory compliance really mean? Also, how can organizations operationalize compliance? And what is a data asset inventory? And we'll then move into classification and what role that plays with operationalizing compliance. And again, we'll end with playbooks and how that simplifies that whole process. So let's start off with that first question, Scott. What does regulatory compliance really mean?
Sure. In this context, let's turn on the Wayback Machine, going back probably 20, 30 years, where data privacy and information security here in the US developed on two different tracks. So you had things like the HIPAA privacy rule, the HIPAA security rule, GLBA privacy rule, GLBA security rule, and so forth. So that was the model that we've been using pretty much since the beginning here in the US. Over in the EU, they use a different model, which is data protection. So essentially, they look holistically at data privacy, data security, two subdisciplines of a larger discipline of data protection. And what's important for the audience here is that even if you don't have to directly comply with these rules and regulations, what you'll find is that you may have to do so indirectly through a contract. And just by way of example, before I joined the team here, I worked on a project for a bank in the Midwest that had no operations in the EU, but still was subject to GDPR because of contractual requirements. So that's the challenge, is that even if you don't handle data because particular kinds of data because you're in a given jurisdiction, you may still be responsible for protecting it because you have it on behalf of your clients. So as a consequence, data classification was developed in the modern realm, in the civilian world, as a very powerful way to address data protection compliance requirements by dropping data in various buckets that are really delimited by how bad the consequences are if something goes wrong.
That's excellent. It's also really good to know that, well, let me ask a question here, Scott. So you mentioned that your business partners could indirectly include your organization with compliance. how does an organization find out about that?
Typically, what will happen is during contract negotiations, you'll get some kind of either language embedded in the contract saying you shall be responsible for all of these things. There may be a rider or a addendum to the agreement that says you shall be responsible. For example, probably the most common one that our listeners are familiar with is a business associate agreement. So that's a very specific set of requirements. Even though you may not be in the healthcare business yourself, you still have to treat that data with the same care and respect and security as you would if you were a covered entity. So, great example of that. And that's very typical in all kinds of contracts, regardless of what industry that you participate in.
Got it. So is that the data processor clauses in a lot of these laws?
Yeah, what you're talking about is the data protection addendum or DPA, and that idea came from the EU from way back when the EU Data Protection Directive first came out. You had this essentially an addendum that was just directed towards the protection of personal data and all the things that you had to do. It's evolved quite a bit, but I still call them DPAs, and I think many of my colleagues still do.
Understood. Yeah, thanks for that. So let's go ahead and move on to the next slide and talk about the current state of U.S. data privacy law,
Sure.
starting with states.
Sure, sure. Happy to, because that's really where the action is currently. So three states right now have what I call rights-based GDPR-like data protection laws. And when I say rights-based, just for the benefit of the audience, that literally this is conferring certain rights to individuals. So right to know what kind of personal data an organization has about you, right to amend it, right to have it deleted, and so forth. So that's in three cases in three states at the moment. In some cases, there's bills that are going around the various legislatures. We had at least 23 introduced this year. I don't know if any are going to make it over the finish line, but this is an idea that continues to gain some steam at the state level. We also have traditional, what I call risk-based state laws. So think about NYCRR Part 500, which is a state law in New York that is designed to protect data that is under the auspices of anyone in financial industries. So banks, credit unions, pretty much just about anyone that even is remotely requiring a license is going to have to adhere to that. So those are the kind of risk-based state laws that we have, and we've had roughly 45 new ones since the 2018
Wow.
legislative session.
Wow. Okay. So I have two questions that pop out in my mind.
Sure.
The first one is for viewers, let's cover the difference between rights-based and risk-based
Mhm.
laws, if you
Sure.
could, please.
Sure. Think about a risk-based law is typically a list of things you shall do to protect data. So, for example, and I'm going to use NYC Part 500 because it's really been a great model. They gave about 14-ish different sets of controls, and I use the term very loosely. So, requiring a CISO to lead your security efforts. That's one of the controls essentially that they've put into place. They have controls on encryption and all kinds of other things as well. So it's very prescriptive. It tells you certain things that you must do. So that's risk-based, and I use the phrase risk-based because you have to establish controls that are tuned, if you will, to the risk inherent to the data. So that's the idea of risk-based. Again, that's our traditional model of doing things, and we put those, meaning legislatures, tend to establish those with some regularity, just because it's generally speaking less politically sensitive.
Understood. Um, the next question I had was I see 45 risk-based laws, and then I'm looking at that federal level.
Mhm.
Do we expect to have, in your opinion, a federal law similar to the GDPR in the United States?
In a word, no. And why that is, that's usually the follow-up question that people give me most, and the answer is just simply at the federal level, for whatever reason, over the last 20-ish years, I've been doing cybersecurity law since 2003. During that period, it just has never become a priority at the federal level, regardless of who's in office, what party, who controls what. It's just not. What we do have in some cases are regulations. So in this case, the FTC has just promoted or promulgated rather. There's new safeguards rule. So the original safeguards rule came out in 2003, and in fact, we'll see that in a bit. And that was updated just recently, and it took about a 2-year process to update it.
Wow.
They've also introduced some breach notification requirements, but still are pretty. It's a pretty low bar to clear vis-a-vis the GDPR.
Got it. Okay. So before we go to the next slide regarding timeline, there is a quick question: will these slides be made available? Yes, absolutely. We'll make these slides available of the presentation. So let's go ahead and take a look. Again, 45 state laws, and then there's a lot more because this is a really
Hmm.
big problem.
Yeah.
Looking at North America and outside of North America, that's an eyesore chart. Can you help us understand what?
Sure, sure. A great way to look at this, and some of your viewers may find this a bit odd, but I really have put a marker down in 2013. That's when the Edward Snowden revelations took place. So really, you have privacy before Snowden, and we had privacy after. And I'll give you a great example: is after Snowden, you found that we had changes in the laws. So GDPR was being debated during the point where the Snowden revelations took place. And as a consequence, that had an impact on GDPR development. Also, the Schrems 1 decision that came out as a result of the Snowden revelations. And so you can see that after the Snowden revelations, there was a much more of a cynicism, if you will, vis-a-vis privacy. And so the protections really were ramped up as a consequence in the international realm. Prior to that, you can see that things were effectively done or effectively put into place periodically. So, for example, you had in the North American side, you had, as I mentioned earlier, the GLBA passed in 1999 and the GLBA rules in 2002. You had the HIPAA rule passed in 2003, even though the law went into effect in 1996. So you can see how things were very methodical before Snowden. Afterwards, things changed on the international realm, and there was responses both in the U.S. So you have NYC Part 500, you have the NIST privacy framework. So lots of big changes, and of course the rights-based laws like CPRA, the Virginia and the Colorado versions.
Got it. So not only is there a lot of laws out there, but they have a lot of details, such as, well, let's go to the next slide and take a look at those contractual drivers. This is,
Sure. Sure.
go ahead.
This is from the CPRA. So this is coming up. It's the first of 2003, although the period where the look back period starts at the end of this year. And so what this is a list of the contractual requirements depending on to whom you, or with whom you're sharing data, service providers versus contractors versus third parties. And the point of this slide is not to brief the audience on all the whys and wherefores of CPRA, but it's to help them understand that there's tremendous complexity at the state level. And so as a consequence, data classification is a means to help you get from here to there.
Got it. So that leads into our next question, which is, this is a really big and complex problem. How can you begin to operationalize compliance? And well, it appears that the answer is going to be to ask the right questions. And there's a number of questions here, such as what and where uh, are our data types and what do they have? Who owns what data in the process? What security controls do we have? How are we going to dispose of these data elements? And well, how do we report on it?
Yes, and in fact, what you're really talking about are the kind of questions that have to be asked and answered in a data inventory. So you think about traditionally, before we had automation, there was a giant spreadsheet, and I can speak from experience because I was, was making giant spreadsheets.
Let me skip the
That
next slide. So
yes,
let's go
yes.
to that.
Well, it's funny you mentioned that because all these questions, and this is a real data inventory, or at least a small piece of a giant data inventory I did previously. And this was all done on a spreadsheet, and it was the function of asking all kinds of questions. And so you can see that there's two systems here that I took a look at. There was, I think in the original one, there was like 100, but you
Mhm.
had an MDM tool and a DLP tool. And so what for the MDM tool, I have a purpose of the processing specifically put there, so that if there's ever a question from an authority, why are you processing? Why do you even have this data? We know. And you may think, oh, that's ridiculous. Why would you ever have to write that down? Believe me, companies were punished because they lost data and because then they didn't know why they had it in the first place, which is pretty embarrassing. In terms of the kinds of data, here for the MDM tool, you have things that you would expect an MDM tool would process, like an IMSI number, an IMEI number, device ID, etc. Whereas for the DLP tool, there are things that you would expect it would process, like an IP address. So the net of it is that you want to get an idea of what kinds of personal data are in scope, and then what regulations apply. And then from there, you would ask yourself, okay, what other questions are going to be necessary to be resolved? So all of those things are necessary to be able to have your data inventory and to be able to keep it as a living document and constantly updating it, it's a very laborious process.
Sounds like it. I want to pause there for a second before we continue. We have an interesting question
Sure.
in the audience. How does the state laws interact with the federal government's data protection requirements, such as complying with the NIST CSF requiring for handling CUI?
Oh, great question. What you're going to find is that in theory, federal law will overrule a competing state law. In practice, I find that just just in my day-to-day practice, in fact, we wind up having to comply with both, because the federal government didn't write out essentially the states. And so you have to include both. And then for very narrow things like CUI or controlled unclassified information, which is really very germane to information that federal agencies share with contractors. Currently, it's defense contractors, but in theory, it's any contractor. As a practical matter, you have to comply with both. And if one is stronger than the other, then you have to go with the stronger of the two. That's what we call rationalizing your data security and privacy requirements.
So does that resolve any conflicts? I realized there was a question I forgot to ask in a previous slide about when two competing laws are in
Well,
conflict. What does stronger mean?
here's the thing is that in principle, the supremacy clause of the US Constitution says that if federal and state law conflict, then the federal law wins. But again, as a practical matter, what you're going to find is that federal law could be very silent on all these things. Or in some cases, it may be co-terminal with the states. A great example, GLBA. As a practical matter, as a state can enforce the GLBA or the feds can enforce GLBA. In fact, all kinds of bodies can enforce GLBA, like the Office of the Controller of Currency. Or you could have the exact opposite. FAA rules are all to the federal government, and the states can't do anything. I mean, anything. It's a very interesting dichotomy. So net of it is that if there is a conflict, the federal will win. But I've yet to see a federal law that would, um, with a couple exceptions, like the Can-Spam Act, that is really going to run over state law.
One last question
Sure.
related to this. Do you expect to see, or how would you resolve? I'm not quite sure how I want to ask this question. Any conflicting state level laws?
I don't usually run into conflicting state level laws. What I do run into is some states have higher standards than others, and so one state may require you to have a 3-day notice, 72-hour notice, versus a 30-day notice, versus an immediate notice that your contract requires. This is the interesting thing: is that people tend to debate, well, how many hours notice should a law have? As a practical matter, for example, our own uh, uh, customers. We have to notify them immediately if something ever went wrong. So the state law really is kind of irrelevant at that point. It's going to be whatever the shortest period of time is, and immediate is our shortest period of time.
Got it. So thank you for those follow up answers, Scott, and
Sure.
great questions from the audience. Please keep them coming. Let's go ahead and move to the next slide, which is what is a data asset inventory? We introduced this concept a little bit earlier, and I know we had a previous tech talk. So a lot of this slide should be review. But a data asset inventory holds that collection of information, the metadata about your data assets and business process within an organization. And it contains that metadata that you want to own or understand about that business process or that data. Scott, if you want to give any a little bit more insight into that.
Sure. I mean, a asset inventory, it's taking what we saw earlier, the idea of something that you would be doing on a spreadsheet and automating it and connecting it to other systems so you can take advantage of all the integrated technology. So it's just a much more efficient way and really a way to add layers of defense in the sense that you're connecting other things and to protect your data and making sure that you're adhering to whatever standards are required, or if you have internal practices, anything like that. So just in sum, it's an automation of the whole data inventory concept I discussed earlier.
Got it. So thanks for that. And although it's not coming through on the slide appropriately, I did attempt to highlight the classifications piece there because that is the key piece for this talk about operationalizing compliance is understanding what the classification of that data element should be. And that's going to be informed by the data asset inventory and your the regulations that you have. So let's go ahead and move to that next slide. And again, Scott, a lot
Mhm.
of wonderful work that you've done here in the past that we get to use again and again because it's so informational. Can you talk a little bit about this classification matrix?
Sure. This is a subset of a much larger classification matrix that I did previously. And what's important here, and this is something that unfortunately, you will get bad advice in the consulting world about how to develop matrices like this. You'll get advice that you should either just pick three or pick four buckets and go with it. The reality is you want to look at the different kinds of data you have and what is the severity of the consequences of mishandling that. How severe is that? And then start mapping the different kinds of controls that you're going to have to employ. And then map that up with the different categories or types of data. So, for example, yellow. You can see all kinds of categories of data here. You've got non-US personal data. You have US personal data that's HIPAA controlled. You have attorney-client privilege materials. So you have things that are very sensitive, but there's even additional sensitivity, things that would produce even bigger problems. So, for example, company financial data prior to public release, a lot of this idea of material, non-public information, that's super radioactive, and as a consequence, you want to have even stronger controls. And the idea is you want to be able to calibrate your controls so that they match your corporate culture, so that people aren't simply going to be going around a control that you throw on there because some law says you have to do it. It's not enough to just put the control on there if it doesn't work. So you have to be able to rationalize that and socialize that internally. And so this process is iterative. What you're seeing here on the screen is something that took me about 9 months to develop, believe it or not. It looks like, I banged it out in an hour. The reality is it took a lot because it takes a lot of debate about what kind of controls are appropriate. And I think the original document here was 18 or 19 pages long, so it was a beast. So just for the benefit of the audience, data classification is very important, but it requires a lot of thought in order to get a lot of value out.
Right. So while we're trying to solve the problem of operationalizing compliance, it does take that knowledge of the law, contractual drivers, asking the right questions about how you handle and operate with data and what the outcomes are, understanding what those outcomes are, building that inventory, and then again, resulting in this matrix, which gives you those labels for classification, which can be applied. So with Spirion, what are those objectives for tactically implementing those things that you're developing outside that solution? Well, it's very simple. We've tried to make that accurate, objective, and consistent. So you have the outputs from the matrix, which have been informed by your data asset inventory, laws, and then contractual drivers. So you can then build out those objective and consistent rules through playbooks. So you can follow the same rule each time, every time. You want to streamline that, minimize user intervention, minimize end user subjectivity. You want to be able to consistently update those rules to make sure that they apply. And that sensitive data drives the outcomes. You have that weighting that we'll talk about in a little bit to understand what you need to look at first and understand that, yes, that data is properly handled. Or if it's not, you can know about it and then take appropriate action. So that's enabled by looking at playbooks inside the solution. So you can build those logical flow charts based on that data asset inventory requirements. You can have decision points that can be nested to make sure those proper actions are applied. Get that visibility by applying weights to those results and you can prioritize those reporting elements. And then you can automate as much or as little as possible as is appropriate. So when you're looking at those decision points, maybe you want to stop, slow down, get manager approval, or just say, yes, this is, again, for example, rot data. You don't need this data anymore. Dispose of it. Go through that process automatically. So I'll stop there, and then I'll shift over to our solution. I'll get a little bit more into the product. So let me go ahead and share my screen. I'll dive into our platform. So you should see, there it is, our SDP platform. And I'll show you an example of a playbook creation. So let's go ahead and go to Scan Playbooks, create a new playbook, and let's call it Scan for PII. And then we'll go ahead and give it a simple description. It starts with asking questions. You know what the questions are based on the classification and the data asset inventory. What data do I have? Is this PII? And then you can create the rule that says, let's go ahead and find that data element. And I'll look for a bank account number and a credit card number just to keep it simple. We'll save that rule. And then you have a decision point. Is it PII? Yes. Well, what do you want to do? Let's classify it at a minimum and go ahead and select that proper classification. In this case, we'll call it PCI. We want to do this automatically. We can do other elements such as restrict access, or we can quarantine that and automate that as well. And then that's the termination point of that playbook. It's very simple to create. If it's not PII, we can ask other questions. Is it something else? Well, in this case, I don't want to do anything, so I'll take no action and then end this playbook here. That's as simple as you can get with a playbook. It's very easy to create. Took me a few moments. You can make it a bit more complex to fit more business rules. So let's go ahead and skip out and take a look at a different result. This one's going to do a little bit more. So I'll pick one of these playbooks, take a look at these results, and look at a playbook execution that has more decision points. I'm asking where this data is. Well, is it in a folder of concern? Is it banking data? In this case, the result was not banking data. So I ask the next question, is it a social security number or password, some types of PII? And again, you're flowing through this flow chart and adding in weighted scores along the way, so you can get that prioritization when you're looking at the results holistically to understand what has to happen. And in this case, I found that the data was an SSN, and it was not older than 10 years old. So I wanted to ask the data owner, do you really need this data? On the other hand, if it was, we know by our rules that in this case, we don't need to have that data around, and I could have shredded it automatically. Again, that's a little bit draconic. However, for the purposes of this playbook, I wanted to make sure that I show the breadth of actions possible. So you can demonstrate that these actions can be done consistently each time, showing those results. Let me go ahead and take another quick switch of screen. So I need to go back here, it looks like. And then I need to switch back to another window. So let's go here and talk about those playbooks in action. So I have a couple of files here. You'll see I've run that scan already. I'll start another one. And while that's running, I'll talk about what's happened in that middle screen. So I have two files of interest here, which I want to bring your attention to: a call log summary and a TCP dump. These would be named differently inside of different elements. So we can see in this case, we have what looks like to be 16 digits there. And we also have what seems to be another 16 digits over here. What makes the automation possible with the playbooks and reliable is those accurate results backed by the business rules you've built, which are informed by that data asset inventory and that classification matrix. All of that's built into the product, and we can assure that those actions happen at each time. In the call log summary, we know this is a credit card. It matches. In the TCP dump, even though it's formatted and has information nearby, we didn't find that. We know that's a false positive. And if I could bring your attention to the screen down here, we're running actions on that data. Because this element has PCI data, well, we know to protect it in some ways. I have some actions happening on the solution that are going to quarantine data, protect it with MIP. We could lock the file with password. We could shred it outright, add in those labels which are appropriate, those appropriate reactions to protect that sensitive data wherever it sits. So you can see I've quarantined a few items here. I've ran some scans and I've applied those labels which are visible to the end user. Again, this isn't subjective. These are information based on rules that you're informing the customer and then taking appropriate actions to those data elements outside of the user's control, unless you want to ask for that input, unless there's a question or some use case you could not cover. So with that, I'll step back into the slides. And okay, so that is what I had today. We'll see if there's any more questions in the Q&A. Scott, if you have any other finishing comments or...
Yeah, I mean, the idea of automating what we described earlier is so important because you think about pre-GDPR, you really had, I think, a pretty good handle. Yeah, when I say you, I mean all of those of you in the audience that are data protection officers or responsible for just by choice or by default protecting personal information organization. Things were fairly well delineated. I think that was very much true of the HIPAA world. Since GDPR and since all these other nations started jumping on the bandwagon and all the changes we've had here in the US, there's so much more that has to be accounted for, and there's so many more questions that have to be answered. And really, just the only way to address this now is to use automation. And I think you've really hit the nail on the head with how you've addressed classification and how you've been able to integrate it into the technology. It's remarkable.
That's excellent. Thanks for that. Now I actually want to bring back one more slide because I really want to finish on this point because it doesn't seem like there's any other way to do this other than understanding the questions to ask. You know, obviously you have to have legal counsel that understands your legal and contractual drivers, but organizations have to start by answering the questions. What do we have? What do we do with it? How do we get rid of it? Informing those executive level questions to create that process for a data asset inventory, be it a spreadsheet or an automated tool or DAI inside of Spirion, is really going to start by helping that problem. All right. So with that, I don't believe we have any other questions in the presentation. So Scott, as always, excellent to work with you, and I'm looking forward to the next tech talk we can do together.
Wonderful. Thank you for inviting me. I always enjoy being on these presentations.
All righty. Thank you so much, and happy holidays, everyone.